Also plain error review, correct?
Yes, that's correct. Under Molina-Martinez and Rosales-Mireles, any amount of extra time that is incorrectly given to a defendant's sentence is, in the ordinary case, enough to satisfy the last two prongs of Olano. It's in Molina-Martinez and Rosales-Mireles. So instead of being inspected and admitted into the United States, he was grabbed by border officials, detained, seized without a warrant, taken into the United States, brought into without being admitted.
Nobody's ever contested this before in any of the prior convictions or this one. So it strikes me that this is essentially a collateral attack, which on this sentence and the prior sentences, which ordinarily I would look for in a 2255 or something like that, but here we have on the direct appeal, and I was under the impression when you pled guilty and agreed to the stipulated facts that was a bar.
That is ordinarily correct, Your Honor. However, under 1326D, it expressly allows, as due process requires, a collateral challenge in a direct appeal when it's a criminal conviction for unlawful reentry. If the requirements of 1326D are met, and we believe that we have met those, as we argued. That is the, when a prior removal is the subject of a criminal conviction, due process requires that the defendant be allowed to challenge that removal. It is an element of the criminal offense. And so that is why it's under plain error review properly raised in the direct appeal. He was taken into the border, brought into the United States without being admitted. The government here is, doesn't even mention that he arrived at a port of entry, muddying the waters even further because that's the key. He was never legally present in the United States, and so he could not have been removed after. In December 2014, when he was an applicant for admission at the border, the only grounds from the record that would be admissible would be having a lack of proper documents, and that requires expedited immediate removal without any proceedings. The only other thing the border agents could have done was initiate removal proceedings under 1229A. So there were two choices they could have done. They had no authority to grab him, bring him into the United States without admission or parole, and hand him over to state law enforcement. So under 1326D, his challenge to that, the validity of that removal is valid. The immigration law officers were absolutely, wholly unauthorized. They are not authorized, they're only authorized to serve and execute federal warrants for federal crimes. They are not authorized to give custody over of a applicant who has not been admitted into the United States over to state law enforcement. They're not allowed to seize and detain without a warrant. So there were violations of due process, the Fourth Amendment, and too many immigration statutes and regulations to count. Dominguez meets the three requirements under 1326D to challenge that removal order here. In fact, what the officers did, the actions described by the government in its factual basis, amounted to the crimes of bringing in and harboring an alien under 1324A, 1A, sections 2, 4, 5, and A2 that would carry prison sentences of between 5 and 10 years. So a violation of due process, which is the third prong of 1326D, has been established. And so the removal was fundamentally unfair. When an immigrant is removed in an expedited process, like the record suggests, and the government has never disputed that point, then the first two prongs of 1326D are also met under this court's precedent and the Ninth Circuit, which was governed the immigration officials at the time. So under 1326D, the three prongs are exhausting the administrative remedies, the first. The second is a lack of opportunity for judicial review. As I said, this court and the Ninth Circuit that governed immigration officials in Arizona have held that when the expedited removal proceeding is, when the removal proceeding is expedited, those two prongs are met. And so the last prong, that the proceedings were fundamentally unfair, this court is required showing that there was a violation of due process and that he was prejudiced. And so in our briefing and here, we've shown violations of due process. In the Ninth Circuit again, where they govern these immigration officials, the excuse me, the violation of due process is met when Border Patrol or other agencies refuse to follow their regulations. Compliance with the regulation is mandated. When compliance with the regulation is mandated by the Constitution, prejudice may be presumed. The regulations and statutes that these officers failed to follow were in part there to protect the Fourth Amendment rights and the other statutory and constitutional rights of those entering the United States. As when he presented at the border in December 2014, he was 21 years old. He had only ever been removed from the United States once when he was 18 years old, and it was a voluntary departure. So his record, as it were, as an immigrant, was very, very good. He had grown up here. He was brought here by his mother when he was 12. So at that point in 2015, when border guards encountered him at the port of entry, they would have had no reason to criminally charge him. There was no crime that had been committed. He was not unlawfully present in the United States. He was only had that one voluntary departure when he was 18. He had no criminal record. And so inferring based on the record that we have and immigration statutes, border guards were supposed to inspect him. If he didn't have the right papers, remove him immediately. If they weren't sure about whether or not he was admissible, they were required to place him in formal removal proceedings under 1229A. And those two things were the only things that the border immigration officers were authorized to do. They were not authorized to seize him, bring him into the country without being admitted. And admitted is a technical term in immigration law. It means the lawful entry of a person after inspection required by 1225 and a determination by officials of admissibility. That did not happen at all. So he was brought into the country by immigration, handed over to state law enforcement. When he was charged with a small drug crime as a first-time offender, and then he was served 6 months, released on 3 years parole. Immigration was waiting. Now he was in a fundamentally different place. He had a criminal conviction that the government had erroneously called an aggravated felony. Now he'd served time in prison. He had a criminal record. And so that kind of prejudice from the unlawful actions of the immigration officials is also another reason to find that under 1326D that this removal was invalid. I welcome the court's questions.
Could you explain why you believe that the Arizona felony was improperly categorized?
The possession for sale of a narcotic drug is not categorically an aggravated felony because it contains drugs on the state federal schedule that are not on the federal schedule. And the definition of aggravated felony as examined by Mullooly v. Lynch and Moncrief v. Holder and other cases requires that the drug be, since the language of the statute expressly says under the CSA, and then it gives the 802 section with the definitions of those drugs. And so this court and Mullooly v. Lynch and the Supreme Court and the Ninth Circuit have also held that if a drug, a state federal or state schedule, drug schedule contains drugs that are not on the federal list, then it's categorically overbroad. Now, if it's divisible, of course, the government could have presented Shepard-approved documents. It did not. And so this court presumes that the categorical approach applies. We submitted, and this court granted, the Shepard documents that were available from that case, showing that he was not convicted of an aggravated felon. There was no drug listed. It was simply the basic statutory language. There's no particular drug, so it can't be determined that it was not the ones that are not on the federal schedule.
And if we agreed with you on that point, what would be the appropriate remedy?
He was not convicted of an aggravated felony, then remand for resentencing in accordance with this court's decision.
Thank you very much. You've got some rebuttal time. Ms. Niemeyer, we'll hear from you.
Good morning, and may it please the court. Julie Niemeyer for the United States. Addressing very briefly the bulk of my friend's argument on the issue of the removals. That issue could have been litigated below if the defendant had filed a motion to dismiss under 1326D. The defendant chose not to do so, and instead he pleaded guilty. That issue is waived. As to the sentence, there's three arguments why this court should affirm the sentence. And I'd like to outline each one very briefly, and then I'll go into each one in greater depth. The first one is prejudice. The defendant has not shown actual effect on his substantial rights because the sentence here was imposed independent of any alleged error. And we have no precedent in this circuit supporting a presumption of prejudice where the guidelines were unaffected by that error. The second argument is error. This is plain error review, and the defendant hasn't shown that the district court erred in applying that 20-year maximum. The district court did not err by relying on the PSR, which reflected that it had used Shepard-approved sources to find that the defendant had an aggravated felony on his record. And even looking at the Shepard documents supplied by my friend on appeal, those documents also confirm a finding that the defendant committed an aggravated felony. And then finally, even if this court were to find error, that error is not clear or obvious. This is not a matter of well-settled law, certainly not in this circuit, and not even in the Ninth Circuit. So let's start with the prejudice argument here. the fact of the matter is, this sentence of 48 months was not affected at all by the 20-year statutory maximum. The PSR reflected that it was an aggravated felony. The 20-year maximum applied. The defendant didn't object to that PSR. The defendant didn't object to any of the materials that were summarized in the PSR. And if we look at that actual summary, on page JA 120 and 121, we see where that is reflected. That issue was not raised at sentencing at all. The government didn't talk about it. Defense counsel didn't talk about it. The district court didn't talk about it. What was discussed at sentencing were the 3553A factors. And that's what led the district court to sua sponte impose a variance. The government hadn't asked for a variance. The court found that a variance was appropriate under these facts and under the 3553A factors. So that's where the court arrived at the 48-month sentence. It had nothing to do with the statutory maximum. And even if my friend was correct about the statutory maximum being incorrect, even if there was a 10-year statutory maximum, even that wouldn't have had any effect on the district court's reasoning as to why a variance to 48 months was appropriate here. So we don't have any actual prejudice. Can we then simply presume prejudice because there was allegedly a statutory sentencing error? And I don't think we can. I don't think there's any authority from this circuit saying that we should presume prejudice from a statutory error where that's not also tied into the guidelines range. Here, the guidelines range was correct. So it's just this sort of argument regarding the prejudice is she just can't make that showing, and this is plain error review, so that's the end of that issue right there. Even if this court were to disagree, the defendant hasn't established error. So here, going back to the PSR, JA 120 and 121, it clearly summarizes that conviction as the defendant pled guilty and was represented by counsel on September 26th, 2012. The defendant possessed heroin for sale. That's the summary. And we know that the court properly relied on that summary because that shows earmarks of being derived from Shepard-approved sources. And that's the standard in this circuit. The court was entitled to rely on facts in the PSR that showed they were from a Shepard source. Those facts are the facts of the conviction. They're not facts about the conviction, they're the facts of the conviction. And the court properly relied on them. Even if this court were to examine in detail the Shepard documents presented by my friend, the court would reach the same conclusion because those documents further establish that this was, in fact, an aggravated felony. When the defendant pled guilty to this complaint, he pled guilty to count one. Count one charges that the defendant, on or about the 26th day of September 2012, knowingly possessed for sale heroin, a narcotic drug. That's the count that the defendant pled guilty to. Now, he did not plead guilty to the amount of that drug. That doesn't matter. That doesn't matter. And we know that doesn't matter because the Ninth Circuit already looked at this question. They examined the statute, and they concluded that the statute, because it was divisible in that particular case, as long as the Shepard documents show that the drug that the defendant was convicted of was on the federal list, then it counts. And the defendant hasn't established any argument for why that is not a persuasive reasoning. So he pled to that count. It reflects heroin. Heroin is on the federal list. It's an aggravated felony. Finally, even if the court disagreed as to that point, any debate about how to classify a conviction under that statute is not a matter of well-settled law. This has been addressed by the Ninth Circuit, has not been addressed by this circuit, of course. But even in the Ninth Circuit, the case there established that that particular defendant's conviction was for a federal substance, just as it was here. That type of analysis hasn't been conducted in this circuit. That's a persuasive case, but it certainly could be up for debate. There are arguments made by my friend as to how it could be classified otherwise, but this is not a matter of well-settled law.
So are you suggesting that the Arizona statute does not fail the categorical approach?
Your Honor, I agree with the defendant that it is an overbroad statute, and that was
And
determined.
so you agree that it fails the categorical approach?
Yes, Your Honor. But under the modified categorical approach, because it's a divisible statute, that permits the court to look to see if the conviction was
Only
for.
if they're Shepherd documents, right?
Yes, Your Honor. Absolutely, Your
And were
Honor.
they here?
I'm sorry?
Were they here? Did the government produce Shepherd documents here?
It did not, Your Honor, because the defendant didn't object to the information in the PSR.
But didn't the government have to produce Shepherd documents if the court was to apply the modified categorical approach?
Your Honor, I would say no, because the PSR summarized the Shepherd documents, and the court was
You said there
entitled,
were- You just said there were no Shepherd documents.
that they were not physically introduced in the district court. That's what I was referring to, Your Honor.
And so how do we know that they were relied upon in the PSR?
That's the job of the probation office, to use the Shepherd documents to represent what a conviction is, and the very description of the conviction in the PSR bears earmarks of having come from Shepherd documents. The first sentence says, "The judgment reflects," goes on to state that, and the second sentence gives the date and the offense, which reflects that it came from a charging document. Once he pleads guilty to that offense, that charging document becomes a Shepherd document. So this court in Thompson and again in Boynton looked at that question and said, as long as the district court relied on what appears to be a Shepherd document summarized in the PSR, there's no error, because the district court is entitled to rely on that information if it appears to be from a Shepherd document. Now, the
Right, but
rest of that
in
paragraph.
Boynton, we actually found the opposite, that there was no indication that there had been reliance on Shepherd documents.
In that case, yes, the facts that were examined in that case showed that there wasn't any earmark of that information having come from a Shepherd document.
And how do the facts here differ?
Because here, the summary is of the judgment, and then only in the third sentence of that paragraph does the probation officer say the probable cause statement reflects da-da-da-da-da. That's not a Shepherd document. We don't need to rely on that information. The court didn't need to look at that information to make the appropriate determination that this was a trafficking offense. Now, that information could be relied on under 3553A because the defendant didn't object to it. But only the first two sentences were necessary for the court to determine that that was an aggravated felony. And that's allowed. In Boynton, there was no indication that the facts summarized in the PSR came from Shepherd documents. So that's the difference here. And I think it's also important to note that the court's authority to look at the fact of a prior conviction, as summarized by Almendarez-Torres, was not overruled by Erlinger. Erlinger actually affirmed that it was not going to disturb the Almendarez-Torres exception. It wasn't asked to do so, and it wasn't going to do so. The Almendarez-Torres exception still applies, and that exception permits the district court to find the fact of a prior conviction based on the Shepherd documents. And that's what happened here.
Well, you just said there were no Shepherd documents, so how do we know that happened?
I'm sorry, based on the summary of the Shepherd documents, which appears in the PSR, Your
Well, you
Honor.
assume that they were summarized. There's no reference to them in the PSR.
Correct, Your Honor. It's a common practice of the probation office to summarize what they glean from those documents and to present it, which they identified in the first sentence. At first, they were looking at the judgment, and then the second sentence, as I've suggested, reflects that that information came from a charging document because it gives the date and the exact offense. I'm happy to entertain any other questions of the court as to the other issues.
Thank you very much.
Thank you, Your Honor.
Ms. Powell, you've got some rebuttal time.
Thank you, Your Honors. To hit the points that the government brought up, first, 1326D does not require the challenge to be raised in the district court. In fact, the very purpose of it is to allow challenges in appeals and collateral challenges. So the fact that it wasn't raised as counsel established means plain error applies, but that is all that her point establishes. Second, the PSR, we disagree that the PSR reflects that the information was taken from Shepherd-approved documents. Again, I'd like to stress they did not present any in the district court, and so, but the ones that we have actually, and this court has granted, I agree with my co-counsel.
What do you think the probation officer was summarizing in the PSR?
Yes, I have the page. I do agree with the government that the first sentence says the judgment reflects. And so I believe the first sentence, similar to what was discussed in this case, court's decision
Indicates that the
in Van.
probation, that indicates that the probation officer was looking at those documents.
That they looked at the judgment reflects that the defendant pleaded guilty and was represented by counsel. Those are the only pieces of information that under Van and other cases in this court that would be considered to come from Shepherd-approved documents. And on that point, he was not charged in Arizona court by an indictment. The charging document, as DeCamp and Shepherd recognized, must be looked at with what he pleaded guilty to, any transcripts of the guilty plea, anything contained in the judgment. So one, the direct complaint that he was charged with was based on the sworn testimony of a law enforcement officer. That's not a Shepherd-approved document. Two, the document itself, the guilty plea, I'm looking at the motion, the guilty plea, page 2, says, paragraph 4, this agreement serves to amend the complaint, indictment or information, to charge the offense to which the defendant pleads. So it's not correct to say that he pleaded guilty to that charge.
Going back to Judge Agee's initial question, none of this was argued below, was it?
That's correct. Plain error applies. Again, under
At best, maybe waiver.
waiver is the intentional relinquishment of a known right. It's not clear that anybody knew the correct law or that's.
Okay.
So the Shepherd documents that we do have modify the direct complaint. They contain no mention of black tar, heroin, et cetera, that's in the PSR. And so I disagree with the government that says that the rest of this can be accepted as taken from Shepherd-approved documents. One moment. So it was incorrect to rely on the PSR. Going to the consequences of this court and the Supreme Court have often noted that when a statute raises a person's statutory maximum 10 years, that is significant. So even if he received a different sentence, the variance of 48 months or such, the significance is being labeled an aggravated felon that has immigration and state and federal criminal consequences in the future that are dramatic and certain, since his family is here and there may be problems in the future. And now being labeled an aggravated felon also harms him as a legal state, the status. This was plain error. We've known the statutes of Arizona and the federal schedules, since they were enacted. The Arizona statutes were enacted, these relevant schedules, I believe in 1996. We've known since 1990 that under Taylor, there's a categorical approach, and you look at the statutes, and you compare the statutes, and you see if they're overbroad. So this was not a plain error. The analysis has been long settled, as well as the modified categorical approach and what that must inquire. Malooly v.
So
Lynch.
what else have you got to tell us this morning?
Me?
Yes, ma'am. Because your time has expired. Is there anything else you wanted to tell us?
Thank you, Your Honor. No, I just wanted to rebut the statements of the government. I wanted to emphasize that he has met the prongs under 1326D to challenge the removal order in this proceeding under plain error, and that he's immigration officials unlawfully brought him into the country when he had not been admitted, he had not been paroled. They turned him over to state law enforcement where it resulted in criminal conviction on his record. He was never legally present in the United States, thus he could not have been removed pursuant to a valid warrant of removal that was outstanding. Thank you very much.
All right, thank you, counsel. We note, Ms. Powell, that you're court-appointed, and the court wants to express its appreciation to you for undertaking representation in this case. So we'll come down and greet counsel and then move on to our next case. Ms. Wanamaker, whenever you're ready.
Thank you, Your Honor. May it please the court. I'm Catherine Wanamaker for Appellant Conservation Groups. This case concerns the Cane Hoy development just outside of Charleston, South Carolina. The Cane Hoy development is not your average new residential development. Rather, it is the creation of a new small city sprawling across 9,000 acres of wetlands and pristine forest habitat bordering a national forest. To transform Cane Hoy into this new city, the developers needed permits under both the National Environmental Policy Act, the Endangered Species Act, and the Clean Water Act. The government's approvals under each of these statutes are fatally flawed. Most glaringly, the Endangered Species Act approval at issue here, the biological opinion issued by the Fish and Wildlife Service, suffers from the exact same flaws as the biological opinion rejected by this court in the Sierra Club case that is cited throughout our briefs in great detail. The biological opinion here, as the biological opinion did in that case, provides an unlimited license to take, which is a term of art under the Endangered Species Act, which essentially means to kill or harm all of the northern long-eared bats on the property in
Well, the
question.
district court seemed to look at that in some depth and distinguish this case from the Sierra Club case. If I'm remembering correctly, the issue there was a very small parcel of land, less than half an acre, next to a hibernating site. And the biological opinion said that the justified take would be a small percentage, which, of course, nobody knows what a small percentage is. But here, if I'm remembering the record correctly, nobody's ever seen one of these bats in this project area. And the adjoining 250,000 acres of national forests, they had seen one or two some number of years ago. So it seems like to me the factual setting is significantly different here than it was in the Sierra Club case.
Your Honor, this is a central flaw in the district court's opinion, and I'd be happy to address it. This case is no different than Sierra Club in terms of the presence of the species near the project area. And in fact, that issue has been decided. The district court committed clear error in holding that.
So why do you say that? I mean, if I remember in Sierra Club correctly, you had lots of bats in that general area, and lots of them in caves near there. They were native to that area, not native here. Why was the district court wrong? You seem to say Sierra Club provides that there has to be a numerical take set every time. And that's just not what the case law says.
It says you must set, Sierra Club says you must set, and the Endangered Species Act and its regulations say you must set a numeric take limit unless it is truly impractical.
And that's what the service found here, that that the bats cannot be practically monitored. And did you dispute that in your briefing? I didn't see
Yeah,
it.
yes, Your Honor, we do. I mean.
So how could the take be monitored then?
The take can be monitored here in the same way that the take can be monitored in Sierra Club. I mean, it's the exact same type of.
But here, I mean, as Judge Agee set out, the facts here are different than in Sierra Club. Here, these bats have not been seen, and only a couple of them several years ago in the adjoining forest, so, which is different from Sierra Club.
Well, Your Honor, I
where
don't think that's correct with all due respect, because in Sierra Club, it involved bats. It involved the northern long-eared bat, involved the Indiana bat, and
Well,
involved.
just because both things involved
No, but-
bats doesn't make
No,
them
but-
similar in the respective practical monitoring ability.
No, but if I may finish, there were multiple species at issue in Sierra Club. There were bats, there was the club shell, and there was a bumblebee. And for all of those species, the service basically said, especially for the bumblebee, And for the club shell and for the log perch, where it set a numeric limit, we have not observed many of these species. Only a few have been found in adjacent areas. Yet, we cannot set a numeric take limit because we don't have local population data. And the court struck that down and said, yes, in fact, you can set a numeric limit because you can survey for these species. And that's the same, it's exactly the same.
And were you able to, I don't know if you finished answering about how the take could be monitored here.
Well,
The
the-
service says it's not practical. How
Again,
could it be
again,
done?
Your Honor, that argument was raised in the Sierra Club case, and it was rejected by this court. I mean, they
But
said
those
this,
are factual determinations that are made case by case. You seem to imply there's some national rule, and there are lots of cases where some non-numerical take has been approved.
but if I may just address the monitoring point. In the Sierra Club case, the service took the exact same position that it's taking here, which is we cannot monitor bat take because it will be difficult to detect dead or impaired bats. That's exactly what they said. And the court rejected that and said, no, you can. You can survey for the bats. You've done it before, and it cited multiple biological opinions.
I thought there was a survey here, and they couldn't find it, and the district court offered you the opportunity to do your own survey, and you turned it down.
Your Honor, it's not our burden under the Endangered Species Act to go survey private property to find the presence
Well,
of
but it
a.
is your burden to put on some evidence. Did you put on any type of scientific expert evidence here?
This is an administrative record review case, Your Honor. The presence of bats, this is what happened, and this is why I say the issue has been decided. The Fish and Wildlife Service asked the developers to survey the site. The developers did not want to survey the site. They agreed instead to assume presence of the bats. The service found bats are likely on the parcel. And now, in the litigation, once we've gotten to litigation, the developers have come in and said, oh, never mind, there are no bats on the site.
I thought they did survey a part of it.
They surveyed, the only survey in the administrative record is 170 acres. And what the service makes clear in the administrative record.
They surveyed 1,500 acres.
They surveyed 170 acres and submitted that to the service for approval, and that is the only survey in the record. They have since surveyed some extra parcels, but we know nothing about those. We don't know whether they complied with the survey protocols of the service, if they were done at the right time of year. The service does not accept, as I understand it, those surveys as proof of absence of the bat. And in fact, the biological opinion finds that the bats are likely on the parcel. So all of this notion that there are no bats on the parcel has been invented in the litigation. And, moreover, Your Honor, I think, just to be clear, if that's really.
What they said was that they can't be practically monitored.
And they said
Not-
that, Your Honor, in Sierra Club for the same exact reasons, and the court rejected that and said they can be monitored. And the George Washington biological opinion cited in that opinion, and the Enbridge.
But then that goes back to what Judge Agee was saying about it's a case-by-case sort of analysis based on the facts of each individual case as to whether or not the particular species could be practically monitored in that instance. And in this instance, the service has found that they cannot be practically monitored, and the district court apparently agreed.
But Your Honor, that is the height of arbitrary. It's the exact same type of clearing and a bat that was at issue in Sierra Club.
Can I ask you a different,
Yes, Your Honor,
route?
sure.
What is the likelihood of imminent harm to appellants?
Well, Your Honor, since the Endangered Species Act approval came out in July, the developers have been out at the site clearing as much land as possible from July until now. And that is, you're getting to the heart of the issue here. All we're asking for is a temporary pause until we can get to the merits of this case. We're asking for an injunction only to get to the merits so that this can be resolved on the merits before more habitat is lost at the site, while there are still available alternatives under NEPA should the court find that an EIS is required. If the clearing continues for the next months or year before we get to summary judgment, our remedies are far more limited. So that is the imminent harm. I think the case law is very clear that when an endangered species is at issue, as it unquestionably is here. I mean, we wouldn't be here if there were not likely take of bats. That's the whole reason we have this biological opinion.
So what's the evidence of a likelihood of the taking of bat? I mean, other than the presumption, which I think the developer did just because they've been at it for so many years and they wanted to move this thing along, I'm just having a lot of trouble finding any evidence in the record that supports your factual representations.
I mean, I think, Your Honor, that the evidence of the presence of the bats and the harm to the bats is clear throughout the biological opinion. I would be happy to pull the JA sites for you.
Well, just give us
but
a real short summary of what that is.
a real short summary. There's a table in the biological opinion, I think it's JA 185, if I'm correct, you can give me the citation, but it has a whole chart that lists all of the harms to bats on this property from the clearing: direct injury or mortality, lethal take in 3 different ways. I mean, that is clear evidence of harm from the expert agency who is charged to protect the species. I guess, Your Honor, another way to explain this case is if they are going to assume presence of the bats and then say, oh, but there's no problem, they're going to, take all these bats, but there's no problem, we wouldn't be here if they had set a numeric take limit at 0 or even 1. But instead, what they've done is assume the presence of the bats.
You would have agreed to a numeric take of 0?
Or 1, sure. Yes, absolutely. I mean, it could have been slight in
There's
the,
a table on JA 184 that says summary table of effects, but it also includes the conservation measures that will be undertaken.
yes, I mean, no question, there are some conservation measures, but those do not take away the lethal take authorized by this BIOP, which is why there must be a lawful incidental take statement here. And, Your Honor, there isn't. It's a carte blanche, take all of the bats on the property. If they had set a numeric take limit at 0 or 1 because they didn't really think bats were on the property, that'd be fine. We wouldn't be here. But that's not what they did. What they did is just what they did in Sierra Club, which is allow them to take all of the bats in connection with all of the planned clearing on this site. And that, Your Honor, is unlawful. And it gives rise to irreparable harm to us in addition to a number of other irreparable harms, including the filling of wetlands, traffic, location of housing in the floodplain. And I will just note, as my time is about to expire, that the district court found no countervailing harm to the developers from a temporary pause here, and that's all that we're asking for.
All right, you've got some rebuttal time
Thank you.
left. So we'll hear now from Mr. McGirdle. And you represent the Corps of Engineers or the interveners?
Good morning, Your Honor. Yes, Kevin McCardle for the federal defendants.
All right.
The district court properly exercised its discretion in denying a preliminary injunction, and its decision should be affirmed. I'd like to briefly address irreparable harm, since Ms. Wanamaker addressed that last, and the public interest before moving on and addressing the ESA issue. In terms of irreparable harm, plaintiffs haven't made the requisite showing, and they can't do so now. The district court entered a scheduling order on November 20th. If there's no dispute about the administrative record, summary judgment briefing will be completed by February 27th. Tree clearing's already prohibited from December 15th to February 15th, and it's prohibited again from April 1st to July 1st. So the plaintiffs would have to show that the limited amount of tree clearing that can occur in the interim would irreparably harm their ability to view bats in areas outside the private cane white plantation, like the National Forest. They haven't done that. On page 183 of the joint appendix, the service found that the project as a whole will not have a measurable impact on populations within the East Coast representation unit for the bat, which is just one portion of the species. No measurable impact. And that's undisputed. There is no contrary evidence at all. So there is no basis for a finding.
What was that JA
Irreparable harm.
site?
183, where the court, the service said, no measurable impact on populations within the East Coast RPU. Then with respect to the public interest, I think it's important to note this case illustrates how federal regulation works to serve the public interest. The petitioners came in, they said initially they wanted to apply for multiple permits to develop the property. And the court said, hey, look, if you apply for one with a master plan development, we can assess the whole thing and make sure that it's adequately protected. And to their credit, the applicant said, okay, we'll do that. It was more expensive and time-consuming for them, but they did it. At the end of the process, they got the permit they needed to construct 9,000 houses that are critically needed in the heart of Charleston's urban growth corridor. At the same time, the Corps secured the permanent protection of nearly 3,000 acres, or in excess of 3,000 acres, on private property, including the most significant wetlands and uplands that will serve as habitat for protected species, and that provides habitat corridors to the adjacent national forest. So this is a win-win. This shows how federal regulation works. And a preliminary injunction in these circumstances would disserve the public interest.
Well, there were, if I'm remembering correctly, a number of proactive things that the developer was to do, put up a bat roost, do some other monitoring and things of that nature. Are those in effect now, the restrictions on the times of year, the time of the year that you can do development activities, all that currently in place?
Yes, there are a series of protective measures that factored into, importantly factored into the district court's decision, and rightfully so. So tree clearings prohibited 6 months out of the year, including during the periods when bats are non-volant, which means they can't fly.
Is
So
that
when-
the listing of conservation measures at JA 184?
Yes, I think JA 184 includes both the stressors and the required mitigation measures. So in addition to the seasonal restrictions, which that's important because the risk of fatal harm is greatest when bats can't fly. But outside of those periods, and the service documented this at page 174 of the joint appendix, the most likely outcome is that the bat will fly to other habitat in the area. And there will be considerable amount of habitat remaining in the project area and also in the adjacent 260,000 acre national forest. So that's a critically important and useful mitigation measure. But in addition to that, the applicants can't use loud machinery right around sunset and sunrise when the bats may be feeding. They can't use artificial lighting. They have to put up bat boxes. There are a series of measures that are aimed at minimizing the risk of lethal harm and significant harm.
So what happens if they do operate during dusk and dawn hours, or they use all this light? What happens then?
Well, then they're deviating from the required terms and conditions, which can invalidate the incidental take statement and potentially make them liable for take. And it also can trigger, separately, aside from the take limit, can trigger reinitiation of consultation because it represents a modification of the action that was the subject of consultation. So if you look at the reinitiation regulation, 50 CFR 402.16, there's several different triggers for reinitiation, not just the take limit. And one is modification of the action. And if they're deviating from the required conservation measures, it's a modification of the action. So there would have to be an assessment whether that requires reinitiation. Now, on the use of a surrogate, which is the key issue here, the service reasonably determined that the use of a habitat surrogate satisfies the regulatory criteria, and there's nothing in Sierra Club that undermines the agency's expert judgment. As Judge Thacker noted, the key reason, documented on page 188 of the joint appendix, that the service used a surrogate is because you can't practically monitor the take of bats on an ongoing basis. That's the point of the take level in the ITS, to function as a reinitiation trigger. It's not just to gin up a number. It's to come up with a reinitiation trigger that everyone can practically apply, and that everyone knows, once it's exceeded, you have to reinitiate. A numeric take estimate here wouldn't serve that purpose, because you can't monitor when a bat flies away to another area and suffers a fitness reduction. And you can't monitor when a bat flies up to 35 miles away. and
Well,
it's
what
eaten
about
by a hawk.
opposing counsel very much likens this case to the Sierra case where we considered bats there? What's your response to that? She argues it's the exact same thing.
It's absolutely not the same. At no point in the opinion did the court say, you can monitor non-lethal take of bats associated with clearing 3,900 acres of property. The court's concern there was, as Judge Agee noted, the service didn't use a true habitat surrogate that could be monitored. It took that amount of habitat and it either applied an arbitrary multiplier, reducing the amount by 50%, or it said a small percentage of bats will be taken. And nobody knew what that meant, and that can't be monitored like a true habitat surrogate can. So that was the principal problem. Now, the court did go on and say, you know, bats might be small, but you've surveyed for them in the past, and you've issued numeric take estimates for the Indiana bat. So you haven't demonstrated that it would be impracticable to calculate a numeric take estimate here. Two responses. That's a distinct issue. Use of a surrogate is appropriate either if you can't provide a numeric take estimate or if you can't monitor take. And the court in Sierra Club never went on to reach that second issue because it didn't have to, because the service didn't use a habitat surrogate in the first place. And I think it's really useful, sort of answers all the issues at once. If you look at the revised biological opinion that the service issued after Sierra Club, which the petitioners referenced, the plaintiffs referenced in their opening brief, you know, it's attached to the petition for review in the Defenders of Wildlife case. And if you pull that up, you'll see, in response to Sierra Club, this is at pages 77 through 79 of that amended biological opinion. The service did come up with a numeric take estimate for the northern long-eared bat, but it was based on hibernaculum counts, counts at a nearby hibernaculum, and the associated swarming range. Using those two elements, they came up with a numeric take estimate. You can't do that here, because the bat doesn't hibernate in coastal South Carolina. There are no hibernacula. There's no swarming range. Then the service said...
Is that in the ITS itself, or is that an argument that's being made on appeal?
No, that's in the ITS for the Atlantic Coast Pipeline.
The absence of hibernacula is in the ITS itself?
Oh, it's in the environmental assessment documented that there are no hibernacula, no caves, and also in the BIOP does document that the best available science suggests that in this area, coastal South Carolina, bats are active year-round. They don't hibernate. They go into short periods of winter torpor, but they don't hibernate at all. I can try to find the site for that quickly.
I understand that that argument is being made on appeal. I just, my understanding from the ITS is it was never made, that was never stated as the reason for impracticability in the ITS.
Well, the service said we don't have density estimates, and without those, we can't come up with a numeric take estimate. And the plaintiffs say, well, yes, you can. Go take a look at the revised biological opinion for the Atlantic Coast Pipeline. And there, they came up with an estimate, but it was based on a hibernacula count. And so the response to that argument is, you can't do that here because the bat doesn't hibernate in coastal South Carolina. And that's not post hoc, it's documented in the biological opinion. And then also, the service noted there that the surveys that the plaintiffs keep demanding are for the purpose of determining presence or absence, which is already assumed here. And it says right at page 325 in note 2 of the joint appendix, those surveys are not robust enough to be used to develop a local population estimate. And also, in the revised biological opinion for the Atlantic Coast Pipeline, the service again said those surveys can't be used to develop a local population estimate. And in fact, you can't come up with one for a project that's going to be conducted over a multi-year period like this one. And finally, the service, even though it came up with a numeric take estimate, it actually used a habitat surrogate to serve as the reinitiation trigger, precisely because take bats can't be reliably monitored. So that revised opinion sort of answers all the issues here, and it's entirely consistent with the service's findings and biological opinion in this case. And the difficulty in monitoring alone is a sufficient basis for using the habitat surrogate under both the regulation and Sierra Club. So that's, I could answer any other questions, but there's no question here that use of a habitat surrogate was lawful. And for that reason, plaintiffs are unlikely to succeed on the merits. If there are no other questions, the district court's denial of the preliminary injunction should be affirmed.
Thank you very much, Mr. McArdle. Mr. Dehart, you have some time.
May it please the court, Judge Agee, Judge Thacker, Judge Berner. My name is Rhett DeHart. I'm a partner at Womble Bond Dickinson in Charleston, South Carolina, and I represent the defendant interveners in this action. I wanted to go back to one point that Judge Agee asked Ms. Wanamaker at the outset. In this case, the plaintiffs, as we all know, have a very heavy burden of proof, and there are two passages I wanted to bring the court's attention to at the injunction hearing in September that shows that that shows that the plaintiffs have not met their burden, and I think the court will find this illuminating. The first passage is on page 39 of the transcript, and it was at the conclusion of the hearing, and the district court noted, and I quote.
Do you have a joint appendix cite for that?
It's, Your Honor, it's 39 of the transcript hearing. I can send it to you, Your Honor. I don't have a joint.
But it is in the
Yes, sir,
appendix
yeah.
somewhere.
Yes, sir.
Okay.
The injunction hearing transcript is in the joint appendix, and it's on page 39 of that. And I'll quote directly from it. But it was an interesting point, and it goes back to your first argument, Judge Agee.
Well, I don't make an argument, I just ask questions.
Yes, sir. Sure helped our argument. Great question. But in any event, the district court asked Ms. Wanamaker, quote, "But you know, I was struck that that I didn't have any scientific support challenging the biological opinion. You know, this issue has been floating around since July of 2023. I've read and reread the biological opinion. Like I said, I've read closer about the bats and woodpeckers, and you know, it's pretty clear this was done deliberately." The second passage from the September hearing has to do with acoustic surveys. As Your Honor knows, my clients assumed presence. In addition, we surveyed 1,500 acres pursuant to the Fish and Wildlife regulations. Not a single long-eared bat was found. And more importantly, in the environmental assessment, and this is at JA 1049, in 2022, the Corps found that no northern long-eared bats have been seen on site, nor are they any known hypercula, winter roost sites, or known maternity roost trees on the Cainhoy property. That's in the EA, so Ms. Wanamaker has this burden to rebut that, and the district court, again, at the hearing, she complained that while 1,500 acres have been surveyed, not the entire 9,076 acres, but the district court, and this is very illuminating, stated, well, quote, "Well, you know, you say that, you know, at any point, Ms. Wanamaker, this case has been pending quite a while, a couple of years, and the biological opinion since 2023. You know me well enough. Had you asked me to access the property to inspect yourself, I would have granted it." Ms. Wanamaker, yes, well. The district court, you didn't do it. Ms. Wanamaker, quote, "We could not go out and survey this whole 9,000 acre property. I mean, there's no way that we could have surveyed 9,000 acres, unquote. And at the end of the hearing, Judge Gergel again said, Ms. Wanamaker, if you disagree with Mr. DeHart about the lack of northern long-eared bats, I'll grant you access and you can do your own surveys. They never asked to do that. My point being, Your Honor, it's impractical for us to survey all 9,076 acres. As noted in the biological opinion, half of the Cainhoy property are wetlands. Some of them are deep water, alligator-infested swamps. It'd be very, very difficult to survey the entire property. It'd be difficult for the defendant interveners. It's difficult for the plaintiffs, and you need not take my word for it, Ms. Wanamaker. I mean, there's no way we could survey the entire 9,000 acres.
Was the 1,500 acre survey considered in the ITS?
No, ma'am, but it was entered into the district court record at the preliminary injunction hearing, and it was undisputed, and Judge Gergel found in his order that, in fact, a northern long-eared bat had never been sighted at Cainhoy. So it wasn't in the administrative record, Your Honor, but it is in the district court record, if that makes sense. There's some earlier surveys that were in the administrative record, but again, Your Honor, I would also point out to some of the factual findings the district court made that as Ms. Wanamaker, you know.
So there were earlier surveys of this property?
Yes, sir, a small number, and then, I'm just giving you the full disclosure, you know, Ms. Wanamaker, the plaintiffs made some claims that the northern long-eared bat population at Cainhoy is essential to the recovery of the species, which is inconsistent with all the evidence. So we, in preparation for our injunction hearing, surveyed an additional 1,500 acres, not a single northern long-eared bat.
What was the earlier surveys? What did they show?
Same thing, Your Honor. Exact same engineer, two separate engineering firms, one employed by my clients, one employed by Pulte Del Webb, not a single northern long-eared bat. In addition, Your Honor, Judge Gergel made some factual findings that, again, the plaintiffs can't show they're clearly erroneous. And it's indisputable, Your Honor, that the last sighting in Berkeley County of a single northern long-eared bat, what you referenced several years ago, Judge Agee, was actually in July of 2018. It was 6.5 years ago. And, you know, Judge Thacker, unlike in West Virginia, these bats are not indigenous. Throughout the history of coastal South Carolina, which is 4 million acres, the South Carolina Department of Natural Resources have only detected 33. You know, we're confident this particular bat, we're extraordinarily confident it's not present at Cainhoy, but nevertheless, we assume presence and we adopted this habitat surrogate because we do have non-endangered bats, and it will protect the non-endangered bats. And in the future, as an officer of the court, I can't say it's impossible that a northern long-eared bat can never go to Cainhoy, but if they do, we're providing conservation measures and mitigation measures that are quite onerous. For example, my clients have owned this property for 90 years. It's a working timber farm, and you know, we can't timber a single tree 6.5 months of the year. One last thing I'd like to.
Can I ask a question about what would happen to the project if the temporary injunction were granted? I understand the cessation of, or the ability to engage in the work would be incredibly short, about 1.5 months. So what difference would it make to the project itself if the temporary injunction were granted?
That's a great question, Judge Berner. I was about to address it. Since we got our amended permit in July of this year, some of our client developers are in the process of building homes. And their process, Pulte Del Webb is building roads and sidewalks. They're doing other site work. And if you've got a partially completed home or a partially completed road or a sidewalk, and you enjoined it in the middle of the winter, it would be a disaster. And it would cause job loss. There are a lot of great middle-class jobs out there, and you're telling people right before, not that the court would, forgive me, but like if there was an injunction entered, you're gonna have a lot of middle-class people that are gonna be out of work. So, I mean, the fact of the matter is, we're making progress right now, and to stop it, for no reason would really have disastrous consequences, not only my clients, but again, a lot of middle-class jobs, so it would have real ramifications.
So it would stop the work in addition to the work that was discussed by your colleague of the
Oh, yes, ma'am.
of the destruction of the,
It would,
Habitat.
because if you look at their request for injunction, that they want to enjoin everything. Tree clearing, any development work, any site work, they want to shut it down completely. So it's not just about cutting trees. I mean, so think if, you and your family had a house being built on Canoy and it's halfway built and a junction's issued, that would be a disaster. I mean, it could cause real damage. And if you go back and look at the request for the injunction, they want to shut everything down. So, and as Mr. McCullough noted, as of this weekend, from December 15th to February 15th, we can't timber any trees, but the rest of the site work, home construction, road construction, I mean, all of it, Ms. Wanamaker wants to stop all of it. And that's just in her motion for injunction. That's indisputable. So it would cause really terrible damage to a lot of innocent people, a lot of middle-class workers. So it really would, it's not as simple as just us not cutting trees. We can't cut trees until February 15th. And does that answer your question, Your Honor?
yes.
Okay. And one last point about irreparable harm.
You're over, so wrap it up pretty quickly.
Yes, sir. Irreparable harm, just 2 points, Your Honor, and please, I don't mean to be disrespectful to Ms. Wanamaker. I have a lot of respect for her, but, her member clients, Kingwood's private property, they can't access it. They can't, we only have a handful of woodpeckers left. We translocated them. But nearby, you can go to the Francis Marion National Forest, 262,000 acres, hundreds of species. You can go to Cape Romaine Federal Wildlife Refuge, 66,000 acres, 22 miles on the South Carolina coast, completely undeveloped, pristine. My point being, Your Honor, if their members want to see wildlife in the Canoy area, there are 2 other options that are much easier, and given these other options.
So they have alternatives to avoid their,
Irreparable
what they
harm.
think is their irreparable harm, but your clients do not.
Yes, ma'am. Yes, Your Honor, that's exactly right. I couldn't have said it better. And then if y'all have any, I'm happy to answer them, but otherwise.
Thank you very
Thanks
much.
for your help.
Ms. Wanamaker, you've got rebuttal time.
Thank you, Your Honor. Just a few quick points. First, on the breadth of the injunction, I mean, the only injunction that we've asked for is one to halt the work that is authorized under these environmental permits. So that's it's tree clearing. We're not asking to stop the construction of homes that are ongoing. There's no record in the district court of loss of middle-class jobs at the site. That argument's never been presented to the district court. In the district court, the developers argued that they would be harmed by the loss of contracts. The district court didn't even address that harm. The district court simply said there's a public interest in healthcare and housing, and that the healthcare and housing piece of the district court's order on the public interest prong was clearly erroneous. We had actually agreed, and this was in the record before the district court, to exempt the hospital from any injunction that was granted. So I think, with all respect to Mr. DeHart, he is overstating the injunction request we made here. We have tried to narrowly tailor it, and we had also agreed to exempt another apartment complex where the construction had already been started. What we are simply trying to do is pause irreparable environmental harm until we can get to the merits. And let me just address the survey point. There's been a lot said today about surveying the site for bats. The only survey that the service considered is
Your motion for injunction on JA 104 asks to enjoin construction work. What does that mean? Just timbering?
Your Honor, if it isn't clear, what we meant is the tree clearing authorized by the biological opinion. That's the work authorized by the
You're
bylaw.
saying that you filed the motion for injunction that included that language and you don't know what it means?
No, I mean, I'm saying, Your Honor, that it naturally means the work authorized by the permits that we challenged. And, I mean, we are asking to enjoin the permit, so the work authorized under the permit, which is the tree clearing at the site. I mean, that's what the biological opinion authorizes. If I may address the survey point, this is from the developer's own consultant. The permittee recognized this is the developer's consultant, not the Fish and Wildlife Service and not us.
And JA what?
JA 1281.
Thank you.
The permittee recognizes the extent of suitable habitat on site as described above. The Fish and Wildlife Service has stated that the action does not qualify for a shortened consultation. The Fish and Wildlife Service, quote, "would require the entire project area, not just clearing limits, to be acoustically surveyed in order to concur with absence. Due to the 123-acre maximum survey area, approximately 75 surveys will be necessary to cover the project area." Then the developers go on to say that this would be infeasible. And so instead, they are going to assume the presence of the bat. They themselves said surveys were infeasible. They agreed to assume presence. There is no burden on the plaintiff in an endangered species case to go demonstrate the presence of a extremely endangered animal on private property. I mean, that is not how the law works. There's a consultation framework where there's a finding made of whether an action may affect a listed species, and that was made here. Presence was determined, and we entered into the Section 7 consultation, which found lethal take of bats on the property. When they find lethal take, they must have a lawful incidental take statement. It doesn't matter if there's mitigation. It doesn't matter if there's no jeopardy. They must have a lawful take statement to serve as a trigger when the impacts of the project become too much. And they don't have a lawful incidental take statement here for the same reasons they didn't have one in Sierra Club. Let me just be as short as I can on the Sierra Club opinion. If you read the opinion carefully, for 4 of the 5 species at issue, where not necessarily because there was a hibernacula, for example, for the bee, there was only one survey that had been done several years before finding a bee. The same for log perch, where where the service set a numeric take limit. For 4 of the 5 species, the court said, you can survey, so you must survey to set an incidental take statement, an incidental take limit. And the same exact rationale applies here. And it's the same type of clearing for bats, the Indiana bat at issue in the pipeline. It was 4,000 acres of roosting habitat, not activities near hibernacula. So, Your Honor, there's no meaningful way to distinguish the Sierra Club opinion from the incidental take statement issued here. The monitoring argument that everyone is raising, I would just urge the court to go back and listen to the oral argument on the Sierra Club case. That was the government's entire argument, that they could not monitor non-lethal bat take. And the court rejected it. It sent the buyout back to the agency, and the agency was able to set a numeric take limit and then monitor non-lethal take with a surrogate. And that, Your Honor, is all we're asking for here, that this buyout be lawfully authored and be able to be implemented so that there is some trigger for reinitiation if the impacts of this project become too great. Right now, there's no trigger. If they are right that there are no bats out there and the take limit is set at 0 or 1, there's no problem because they'll never take a bat, they'll never enter into reinitiation. If there are lots of bats out there and there's lethal take as the buyout predicts, there's no means right now to reinitiate. We will never reinitiate on this project until 3,900 acres of forest have been cleared. It doesn't matter if that takes 1 bat or 500 bats. And that, Your Honor, is unlawful, and it's unlawful for the same reasons that the ITS was unlawful in the Sierra Club case. Thank you.
Thank you very much.
welcome.
We appreciate the arguments of all council. We're going to come down and greet council, and then we're going to take a very short recess.
This honorable court will take a brief recess.
question and then a well-settled, clear rule. The question is, when does a crime end? The rule is statutory construction, and under the normal rules of statutory construction, when the statute we are considering is plain, has clear, unambiguous language, then we look at the plain language and the context in which it's used, and we give it its ordinary meaning. The two statutes in play are 844H1, which is the use of fire statute. It's an enhancement statute that adds 10 years to a sentence when the person uses fire to commit a federal crime. The second statute is what I would call the underlying statute, but there's two pieces to this, and that's 2261, which is the interstate domestic violence, which outlaws a person who travels in interstate commerce with the intent to kill their spouse, and in the course of or as a result of such travel commits a crime of violence against that spouse. The crime of violence at play in this case is murder. So there has been some disagreement in the briefing about what the underlying crime for 844H1 is. I don't think that really matters because you cannot have interstate domestic violence without a crime of violence. The crime of violence is murder. So what the district court found was that interstate domestic violence can expand the crime of murder beyond what we would call the logical endpoint.
Well, the crime actually is interstate domestic violence. That's what he was convicted of. So the question is whether he used fire to commit interstate domestic violence. And it seems to me your best argument is the interstate domestic violence ended when her life ended, and she was burned after that.
Correct, Your Honor. The novel part of this is that no court seems to have addressed the scope of this statute, but the reason I reference murder is because the underlying crime of violence in this case was the murder, which this court in United States v. McCoy in 1983, then the Supreme Court in some pre-1900 law has said murder ends at the killing of the victim. So by logic, then the
Right,
interstate...
I don't even think we need a case to tell us that when you're dead, you're dead.
And I think that's where we got hung up in the district court. And if you look at where the district court kind of reached the ruling on this, what we talked about a lot was a continuum. And he found that this interstate domestic violence crime occurred on a continuum. And then during the briefing, I think we got into this question of whether it was a continuing offense. And I believe in the ruling, the district court did in fact find it was a continuing offense, and that's what the government has argued. In our reply brief...
And now the government relies on this Halim case quite a bit. I'm not sure I'm pronouncing it correctly. What's your response to that? Can you distinguish Halim?
So Halim, I said Halim, but I don't know
Okay.
that any of us are doing it right. But if we say Halim, since that's what I'm used to saying, I don't think it addresses the right question, because what the defendant in Halim was saying is the crime of violence, which in that case was an assault, happened before the interstate commerce.
Right.
I'm
Wasn't there a
sorry,
critical distinction there that the victim was alive?
I
And
think-
here the victim died before the use of the fire?
I think there are multiple critical distinctions. The first answer to your question is yes. But in Halim particularly, what is happening is the crime of violence occurs and then the travel begins. So what the court was asked to consider was, is there a beginning point to the interstate domestic violence? And I don't take any real issue with Halim, because what the court said is the beginning point was the assault, and it continued through the travel because the assault is I suppose, continuing. But they were never asked to say, when did it end? And the question here is, and Your Honor said it at the beginning, and I think you're right, that unfortunately when a murder occurs, that is the end of the crime. And there's not any case law I can find or any theory under the law I can find where we would allow a crime with a definite endpoint to continue past that endpoint. What we got into in the district court, what we've argued extensively in the briefing, is Grunewald. And I understand that that is a Supreme Court case from the 50s that talks about conspiracy. But the reason I think it gives us a good framework is because the court recognizes in that opinion, and I think this court and all courts have recognized, conspiracy is the broadest net we use to capture criminal activity. So if you think of conspiracy as the outer parameters of what we would allow courts to consider, those are the ones where we have series of events that usually lead to a conspiracy. But what the Supreme Court said in Grunewald was, after the object of the conspiracy is achieved, the next set of acts that take place solely to cover that up or to, if you will, get away with it, are not part of that crime. They are not part of that conspiracy. So if you take that and apply it logically to a crime like murder, once the murder occurs, anything that happens after that murder is a new set of criminal activity. And there is case law that we didn't really get into because it's a little bit of a side street, but about accessory after the fact and when that would occur. So one of the ways I thought about it in my head was if the acts that had occurred here, the fire, were committed by a person different than Mr. Florentine, but in concert with him, if you will, would that person be chargeable as a principal in interstate domestic violence? And the answer is no. That person would have to be an accessory.
Does the record reflect the time lapse between the murder and the burning?
It doesn't. I think that was probably part of the issue with bringing this as a motion to dismiss, that we had to be limited in the amount of factual dispute we came up because we were going to walk ourselves right into a trial. Our position is the government conceded that the murder occurred. There is a time lapse of some time, and there is then the use of fire.
Does the government concede where the murder occurred? Do we
So-
know what state the murder?
We talked about this in the sentencing, but it'd be disingenuous for me to tell you that I established these as facts on the record, but we had made the argument and were prepared to prove that it occurred in South Carolina. And in fact, I think the government in a footnote mentions that there was a Kentucky state capital charge that was then brought in South Carolina because there was a finding in the pretrial investigation that the murder had not occurred in Kentucky. So the Kentucky authorities brought it here. Again, to be fair to the government, I don't think I can stand in front of this court and candidly represent that we established all those as undisputed facts. But what I think we needed to establish for the purpose of the motion to dismiss was that the use of fire occurred after the death of the victim. And I think that that's clear and that answers our question. Because, use is, even though this seems like a novel issue, there's a case out of this circuit called Barnett, which says the language in 924C and the language in 844H are more or less identical, but 924C requires a gun and this is a fire. But they say because they're identical, you can use the case law for the same interpretive points. So Bailey, which is a case that was a big deal in the 90s when the use of a firearm came about, and there was a question about how broad the definition of use was. Bailey in the U.S. Supreme Court kind of narrowed the definition to such an extent that we don't deal with that version of 924C anymore because Congress amended the statute to make it a broader, have a broader target. So what Bailey says, and I think the best definition of use is that they talk about how we give them ordinary meaning in the context of how they're used. And there's a line out of Bailey that says use, when we're talking about this firearm, it is an operative factor in the predicate crime. And that, I think, answers the question for this court that this fire was not an operative factor in the killing of the victim in this case. So whether we call it murder or you're right that it's accurately called interstate domestic violence, the fire does not operate to accomplish the death of the victim. And because of that, it's a pretty simple question under rules of statutory construction that we don't go any further. Now, in the district court, we got a little bit hung up and we did go further, and that didn't change, in my opinion, the answer. But I don't know that we get to go any further when the language is not only that clear, but we have very clear Supreme Court precedent telling us what it means and actually resolving a very similar issue where there was a question about how broadly can we define use. And the Supreme Court said, you use it in the commission of the crime. It's an operative factor. So
The district, thank you. The district court judge explicitly stated, is my recollection at the sentencing, that this exact same sentence would have been imposed. So even assuming we were to agree with you, why would we vacate the sentence?
So when I look at all the cases where this court has done this, I think they call that the assumed harmless error theory. Almost every single case I looked at that involves a guidelines determination, which I think is very different than whether a statute with a mandatory consecutive minimum applies. The only case that I found where they did not send it back for resentencing on a statutory matter, I think Banks, that the government cites in their brief, and I in my reply brief, I cite where I went into the PACER documents to find out exactly what happened. And in that case, there's multiple counts, and let's just say one of those counts he imposed 30-year sentence, and on another count 10 years concurrent, but clearly the 30-year didn't get vacated, the 10-year got vacated. So that doesn't have a huge effect on the 30-year sentence. And then there's also a case fairly recently, United States versus Lee from earlier this year, where there was a statutory enhancement that they did not send back. But it was also different because it was a prior conviction, and they said there was overwhelming evidence the prior conviction had actually occurred. So there was no real question that they weren't going to be able to go back and challenge that. So if we get into...
Well, you've got to, to follow along on that question, you have what looks like to me basically the pronouncement of an alternate sentence, because the district court says fairly clearly, if they had agreed with you and had not applied count 4 for the mandatory consecutive sentence, even if that count had been dismissed and I had simply treated it as relevant conduct, I would have imposed the same sentence as an alternative variance sentence in light of all the facts and circumstances. And if it's later determined that I have not calculated the guidelines properly, I state for the record I would have imposed the same sentence, again, as an alternative variant sentence in light of the 3553A factors, et cetera. So it kind of circles back to Judge Berner's question. The district court has given an alternate sentence here and has explained why the district court would do that. So why would we send it back?
I'm going to try to answer your question in my remaining time. I've got 3
Go
points
right
to make,
ahead.
Your Honor. The first one's philosophical, that I think there is a serious problem that I have fought against in many appeals unsuccessfully. But the idea that we say we are going to rule a certain way, we're going to rule against you, but even if we didn't rule against you, we would do the same thing. And then now I'm forced on appeal to answer this question, which I don't know what the district court's thought process was necessarily, but I think it's fundamentally unfair that we have this hotly contested legal issue that we then don't, in fact, give you any grounds to go anywhere with. I think as a legal matter, there's a distinct difference between adding 10 years into what would be right now, and if I can answer your question, I'm
Please,
out of
go
time.
ahead.
There's a within guidelines sentence that is what we're faced with right now, assuming that the district court was correct. If the district court was incorrect, then we have a 50% variance, which this court, looking upwards or downwards with that extreme amount, has been, I think, hesitant to allow on anything less than a pretty significant explanation. And the problem that kind of leads to my first point is here, that now we need to argue whether the facts here properly supported a variance, and I don't think they did, because what he essentially says is, this is extreme conduct, but all the facts cited in support of that are actually nothing more than a heartline case of second-degree murder. So I think it's probably, there are times in the guideline cases where that is okay, even though I would still argue against it, because that's a lighter decision, if you will, but not on a statutory consecutive mandatory minimum, of which there are very few. I'm out of time, so I'll have some
Well,
time
you've
for
got
questions.
some rebuttal time.
Yes, sir. Thank you, Your Honors.
All right, Mrs. Washington.
May it please the court, Lisa Washington for the United States. This court should affirm the district court's denial of Mr. Florentine's motion to dismiss count 4 for failure to state an offense, because his use of fire to burn parts, identifying parts of his wife's body to conceal the fact that he had shot and killed her, was in and of itself part of the continuing offense of interstate domestic violence. And
The way you just described it sounds like it might be part of offense of obstruction of justice, because you said to conceal parts of the body. But how is it you can use fire to commit interstate domestic violence when she is already dead after, when the fire is used?
Well, I understand that the murder is the crime of violence in this particular case, but as the court knows, interstate domestic violence has alternating crimes of violence. This one happened to end in death. In addition, Your Honor, you're correct, Judge Thacker, that the government relies heavily on Hillam and the domestic violence statute explained in that particular case. In Hillam, the court recognized both the language of the statute and the purpose of the statute in terms of whether or not.
And isn't it a key distinction that in Hillam, the victim was still alive when she was forced or coerced to travel in interstate commerce?
Well, that's what the defendant argued in that case, that it wasn't part of the course of conduct of interstate domestic violence because the violence occurred prior to travel. The purpose of the interstate domestic violence statute, as the court recognized in Hillam, was to address abusers who, recognizing the consequences of their actions, their violent acts, take to the highways in order to avoid detection from law enforcement and to hamper state prosecutions
Yeah,
of their
all of this
offenses.
still sounds like obstruction of justice, not an interstate domestic violence charge. The interstate domestic violence resulting in death, how did that offense not end when the death resulted?
Because, Your Honor, well, as I just said, the death happened in this particular case, but the interstate domestic violence contemplates various crimes
All
of
right,
violence
but we're talking
that do
about
not
this
end in death.
particular case.
The death, the death resulting language or the element of the death resulting in the interstate domestic violence statute, Your Honor, goes to the harm caused. All right. There is no authority for the argument that the murder, the intrastate crime of violence, controls the end or the termination point or the scope of the interstate domestic violence offense. No authority for that. If Mr. Florentine's argument is accepted.
You're arguing a different crime, whether it's obstruction of justice or interstate domestic violence to a corpse, which is not, I'm not aware of that being a federal crime, but it just doesn't seem to me to make sense that you can have this continuing crime to a corpse. I mean, there are obviously state laws that would apply in that circumstance, but we're talking about a specific federal statute.
We are, Your Honor, and the text of that statute in and of itself contemplates a much broader offense than a discrete point-in-time offense like murder is. In the course of, as a district court found.
The statute itself suggests that the victim is a spouse, intimate partner, or dating partner. Once the individual is deceased, they are no longer any of the above.
It does, Your Honor, but that's not the starting point of the offense. At the start of the offense,
Right, but the fire occurred after the ending point of the defense, when the individual was no longer the spouse.
Well, that kind of goes to our argument that it is a continuing offense. It is not a discrete point-in-time offense about when.
Well, when would it end?
Yeah.
How long could he drag her body around the country and then burn it?
That is an interesting question, and it's one that concerned the district court.
I mean, how would we write this if we agree with you?
What I would point the court to, and the government realizes that the kidnapping statute under 1201 is a completely different statute, different language. However, the intent in enacting the kidnapping statute for interstate domestic violence was very similar to the intent of Congress in enacting the interstate kidnapping statute under 1201. It was intended to detect and prosecute those individuals who took to the interstate highways in order to make their crimes more difficult to detect and prosecute by state law enforcement. That was the purpose realized or recognized by this court in United States v. Horton. It's a 2003 kidnapping case. It's not cited in the government's brief, but it's provides a very good comparator as far as the interstate domestic violence statute is concerned. The Supreme Court has determined that the interstate kidnapping does not end until the victim's body is abandoned. It does, not necessarily abandoned, but set free. That's Rodriguez v. Moreno. In United States v. Zayak out of the Second Circuit, a more recent case in 2014, that court determined that a deceased kidnapping victim, the offense of kidnapping in that case, whether the victim is killed, does not end until the victim's body is set free. The government believes that in this case, the crime of interstate domestic violence ended when Mr. Florentine buried his wife in the cemetery in Kentucky.
Well, let's change the facts a little bit here. Let's assume that the defendant, he kills his wife, goes to the cemetery in Kentucky, but he doesn't burn her then, he just buries her. Then he decides, I need to do something about the evidence, so he goes back and digs her up, and then he burns her. Is that still a continuing offense at that point?
Well, Your Honor, it's the government's position that once, and as I just stated, that once the victim or once the defendant abandons the property, abandons the body, sets the victim free, in a case of death, abandons the property, the continuing offense ends. If I'm going to make the comparison between interstate domestic violence and kidnapping, I'm going to make it consistently.
The statute that you're referring to, the kidnapping statute, actually says in the statute, regardless of whether the person was alive.
Correct,
And the
Your Honor.
domestic violence statute doesn't contain that language. And so it strikes me that the lack of the similar language helps your colleague.
Correct, Your Honor, and the government realizes that it's a different statute. I'm pointing to the kidnapping statute just to point out that the Congress's intent was similar.
Well, it shows that if Congress wanted to include facts such as that in this case, it could have done so. It knew how to do so, and yet decided not to.
Correct, Your Honor, and that language was added as a jurisdictional element to determine whether or not, to make it easier on states, on prosecutions, as far as determining whether or not we had met the jurisdictional element, did not see fit to require the government to prove the status of the victim at the time the transportation began. It's relevant, of course it is, but I only point to the kidnapping statute to direct the court's attention to the congressional purpose in enacting it. And that is what this court recognized in Hillam. The purpose in enacting the interstate domestic violence statute was not solely to punish domestic violence, but it was also to address the situation where abusers or batterers took to the highways to make their crimes less easy to detect. And that in of itself references or indicates an element of concealment. The government's position in this case is that the burning of the victim's body is an act of concealment under Hillam. And for that reason, the government believes that the 10-year consecutive sentence under 844 was appropriate.
Well, and the district court said that it would give the same sentence even if it was incorrect about the use of fire here. So I don't understand why the government is spending so much time on this sort of tortured analysis and interpretation of the statute and not just maybe conceding that and saying the sentence is still the sentence, there was an alternative sentence, and that's the end of it.
Your Honor, for the reasons found by the district court, the government does believe that interstate domestic violence is a continuing offense that included.
Well, you can, I mean, I understand the government believing that interstate domestic violence is a continuing offense, because it is, and it can be in some cases.
But it has to end sometime.
It does, Your Honor, but the crime of violence element is no more important to the offense than any other element. If Mr. Florentine's argument is accepted, then the crime of violence could occur and end the offense before interstate transportation even began. And that's completely flies
Right,
in
and
the face
that's
of
not a
Hillam.
federal crime. Then
And it's-
that would be a state crime if there was no interstate nexus, unless the defendant used a firearm and maybe there was a federal, or he was prohibited from using the firearm.
Correct, Your Honor, but more importantly, it would fly in the face of Hillam. That's exactly what the defendant argued in Hillam, that his violence occurred prior to transportation. That's the argument that Mr. Florentine is similarly making, and if
But
that
that the
argument is
violence,
accepted.
and she was alive, the violence occurred prior to transportation, but the violence that occurred was a part of the coercion and forcing her to travel in interstate commerce. That's why those matched up to make an interstate nexus appropriate.
Your
But
Honor-
there's no similar matching point here. I really would like to hear an argument about why an upward variant sentence of 10 years is, why we shouldn't remand for a full resentencing.
Your Honor, the district court made it abundantly clear that it would impose the same sentence if it had granted the defendant's motion to dismiss count 4.
Did it explain why?
It did, Your Honor, over 9 or 10 pages of the sentencing transcript. The transcript, the hearing was very lengthy. In 9 or 10 pages, the court discussed the reasons, number one, why it was denying the defendant's motion for a downward departure and only granting the government's motion for an upward variance conditioned on the error or lack thereof as to count 4.
Well,
From page-
the district court at the bottom of 321 and the top part of 322 explains the variant sentence, but to go into Judge Berner's question, I don't see there where the district court says it's 10 years, not 5 years, and here are the parts of 3553 that make me do this.
Your Honor,
Where are the 9 pages you're talking about?
beginning at JA 307 through 317.
And does the district court tie that to the variant sentence?
The district court does, Your Honor. It starts out by saying, in our society, the taking of a human life, which is about as serious as an offense there is, the defendant's actions after shooting constituted extreme and aggravating conduct that go beyond the heartland of cases like this. He goes on to talk about the deliberate decisions that the defendant made in committing this offense over a course of days. Talks about the egregiousness and the heinous nature of the offense at JA 315. It continues on and says, and describes exactly what the defendant did. Talks about the body being secreted and transported across state lines and the calculations that the defendant went through in order to cover up his crime, that is the shooting, by burning the body. The district court not only found that the burning constituted a desecration, but it was particularly offended by the defendants doing so and how that affected or deprived the victim's family of being able to bury or for that matter, based on the burning, the hands and the face, being able to determine or identify her and determine where she was.
So I see at the bottom of the last paragraph on 316, the district court does reference back to what you're describing.
Right. Where the district court said, for those reasons, I do believe that an upward variance to a degree is warranted.
Yes, Your Honor. And condition it, the only dispute in this case was whether a 10-year consecutive sentence was going to be, was lawful. When the district court decided that it was going to determine that issue and deny the defendant's motion for dismissal, it had decided that 360 months was appropriate in this particular case. The defendant asked for it, and if it did not believe that 360 months, if it wasn't set on 360 months, it could have taken it off the guideline sentence. Not only did it not agree with the defendant and sentence him to a term of 18 to 22 months, the court actually issued a guideline sentence of mid-range, 240 months imprisonment. There's plenty of evidence in the record, Your Honor, to support the district court. The strongest of which is the district court saying that it would impose the same sentence regardless of the
Right,
ruling.
but in that alternate sentence, there was a significant upward variance, and in order to justify that, the court needed to address specific factors, the 355A factors. And all of the things you listed, are those 355A factors?
Those factors, beginning on page 307, Your Honor, the district court considered were the history and characteristics of the defendant. The government's motion was based on extreme conduct and the aggravating circumstances of the case, but it also considered, the court also considered the nature of the offense and the seriousness of the offense, as it explained on page 307 of the JA.
So page 307 of the JA at the bottom starts with the district court saying that it's gonna, with respect to the 3553A factors, that's how it starts. And then it goes on for 8 or 9 pages, as you say, discussing the 3553A factors, and then concluding with, for those reasons, I do believe that an upward variance to a degree is warranted based on the aggravating facts under 3553A. An upward variance is supported. So that supports your argument that the district court did consider all those factors and tie them to the upward variance, I think. Right?
It did, Your Honor. The government agrees with that. I'm happy to answer any additional questions that the court may have.
All right, thank you very much.
Thank you, Your Honor.
All right, Mr. Kendrick? You have some rebuttal time. So if we assume we agree with you on the issue of when the crime began and ended, what about the argument that the government has set out most recently with respect to the alternate variant sentence and the explanation that it gave?
That's the most difficult part of this appeal, Your Honor. And the problem that I have with allowing that to insulate the issues is that you are just going to see that all the time. So in a guidelines world, I think it is not the correct way to view it, but I can understand why you might. If the court says, I didn't give him, or I'm gonna give him 2 points for the gun, but if I didn't give him the 2 points, I'd probably still give him the 20 months that guideline enhancement sort of applied to. And that's why there's some 30, 40, 50 cases where this court has the assumed harmless error on guidelines issues. And I think we know, based on the body of law we have on advisory guidelines and on how this court views sentencing, that may be something that we, well, I have to live with it whether I want to or not, but it may be something that I understand. But this is very different because you have a sentencing range that is statutorily all the sentences. So murder in federal court is 0 to life. This was not a death case by the time we got to sentencing, but any sentence would be appropriate. The guidelines begin to play a more important role in evaluating how we handle these cases in a case with that broad of a sentencing range. So second-degree murder, and I recognize that I'm often up here probably arguing against the commission's findings and writings of guidelines, but I think second-degree murder carries, if I remember correctly, it comes out to 17 to 22 years, 18 to 22 years, something like that, and that's your heartland murder cases. And what Judge Coggins did, or the district court did in this case, was said, this is middle range, the 20 years, and then I'm gonna add the 10. I think the concern we have now is that you have this 50% upward variance, which is an upward variance from the middle of the guidelines. It's based on extreme conduct that occurred after the murder, which was a subject of a departure motion, which is kind of a leftover type thing we do from back before the guidelines were advisory, but it still has a role to play, and that was denied. So finding extreme conduct as a departure ground was not given, but then all the variance factors relate to these things we've been talking about, which are not outside the heartland of any murder. Basically, that not only did he commit the murder, but he tried to get away with it. And that, I shied away from this quote that I put in one of my motions because I don't think I understood it, and I stopped understanding it, but the Supreme Court talks about how trying to cover up a crime is concomitant since the Abel and Cain murder tried to hide it from the Lord. And I thought for a minute, maybe that goes against me. But what I think they're saying is that doesn't create any special, unique world. Every crime involves trying to get away with it. And what happened here, especially when you get into extremity, I don't know, and it's hard sometimes making these arguments, but it's the job we're tasked with, that the extremity after the killing, I think, has got to be much different and explained in a different way, to take the killing and multiply the sentence by 50%. And that puts us in this position, that we have essentially raised a valid legal issue that needs to be addressed, because there is no court in the United States that has looked at the use of fire statute under these circumstances and put what I would call the limiting principle on it, that it does not apply after the end of a crime. But then we end up in a situation where it doesn't really matter because we would allow a court to insulate the legal decisions by saying, well, that was probably a good sentence anyway. And I think the two need to be separated. If they were incorrect in adding the 10 years consecutive to the middle of the guidelines range, then we need to go back and have resentencing. What we don't want to do is take this record and say, well, you were completely wrong, and not completely wrong as in, I mean, there is no law on this, so this was a novel issue as it stood. But to say you didn't rule correctly under the law, but it won't make any real difference. And I get that that is more of a, again, philosophical argument maybe than a legal argument, but we are up here to determine the parameters of criminal law. We have the opportunity to do that in this case. It should have an effect. And if we go back for a full resentencing and the judge imposes a 30-year sentence on an upward variance, then that may very well be appropriate. It may very well not be. I think the worry is that, you know, in the 2 minutes I have, I don't want to belabor the court because I can tell from your questions you have read the record. But I can tell you that what I see in the joint appendix does not line up with the very large upward variance that this represented historically. When we see variances up, and again, I sometimes get caught up in saying upward or downward. If he had said, you know, I'm going to give him 10 years, period, because of the statute, because the rest of the sentence is 0. I mean, that would be an extreme departure down that you would look at very, very carefully. And it doesn't matter which direction, I said departure, I mean variance. It doesn't matter which direction the variance goes. It matters how big it is. So I will candidly tell the court that that is the one thing I have struggled with the most in this appeal is the fact that he made that alternate variance sentence, which seems to take the legs out of this argument. I think that we should discourage that as a way to avoid tackling these difficult questions, send it back for a resentencing, and I hope Judge Agee, I didn't make a mistake, but I did use my rebuttal time under your assumption, even though I know I can't assume that you agree with me on interstate domestic violence, but I do think our argument is correct. I think there needs to be a limiting principle here that an offense ends at a logical, clear endpoint, and I think the damage from not doing that to the rest of the law would become extreme. And the last thing I'll say is that kidnapping is the perfect analogy. Congress decided they wanted it to extend past the death of a victim. They wrote it into the law. They did not write it into this one, and under the case we cited in the brief, the Discover Bank case, that silence means something. Thank you.
All right, thank you. We appreciate arguments from both counsel. Mr. Kendrick, we note that you're court-appointed, and the court wants to express its appreciation to you for undertaking the representation here. So I'll ask the clerk to adjourn court for the day, and we'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.